Well, many are starting to return back to work after working remotely for over a year. Being back in the office, well, it's going to look a little different and it's going to feel a little different. Maybe some are searching for a job because their hours were cut during the pandemic. For the next 15 minutes or so, we're going to answer questions about your rights as an employee, as well as the process of filing a workers' compensation claim. So to help answer those questions, attorneys Nicole Patino and Jennings are joining us on Two Wants to Know, and we're taking your questions as well. Now, here's how you get one of your questions to one of these experts. You text that question to 336-379-5775. Again, this is a text only, so please don't call. All right, so first and foremost, let's ask the big question that's out there that I get emailed almost every single day, Nicole, and that question is, can my employer require me to take the COVID-19 vaccine?
They can right now. There are two exceptions: a sincerely held religious belief and under the Americans with Disabilities Act, there's an exemption. But otherwise, yes, the employer can require it.
Okay, and so people would then ask, well, why is it that they can require it?
The EEOC says that they can, so the federal government says it's okay unless they fall into one of those two exemptions.
Okay, and then you have to kind of document that kind of thing. All right, so Barry, let's talk about workers' comp here. What if something happens and someone needs workers' comp? The first question is, people ask, how do I file a workers' comp claim? Where do they start?
Sure. Well, the first thing you do is you get hurt on the job, you should go seek medical treatment. But, go notify your employer first. That's the very first thing. Notify your employer, ask them to provide you medical treatment, and then go seek treatment. Once you've got the treatment, then what the North Carolina law requires is you to file a written notice within 30 days. But there's some exceptions to that. The main thing you want to do is let your employer know as soon as possible. By law, the bigger thing that's also important is once you've gotten some medical treatment, once you've kind of gotten an understanding of what's going on with this injury, you need to file something called a Form 18. That's an industrial commission form. That's the state agency that covers workers' comp. And if you go to their website, they have a great website. You find a Form 18, and that's what you need to file. You've got 2 years from when you're hurt to file that. But again, first 30 days is key. You want to get your employer on notice and get your treatment that you need.
And when you say you want to get your employer on notice, do you have to put it in an email or put it in a text or something that you can pull up and show later? Because a lot of times it's a he said, she said kind of thing.
There's no question about that. I see it every day. I get calls from folks every day who are dealing with that issue. And definitely put it in an email, text message. A text message works fine. Something where you can show, hey, I told my employer I got hurt. Put a date with it, describe what happened, be clear about your injury. One of the biggest problems people run into is they get hurt, they don't think it's a big deal, they don't tell anybody, and then it gets worse. And then, insurance company, employer is questioning what's going on, people are coming to me. If you've got it in writing, it'll really help you at that point.
All right, Nicole, let's talk about COBRA, because the American Rescue Plan changed the way that COBRA functions. What is it that we really need to know?
That's right. So employees who have either had reduced hours, so they're no longer eligible for health care through their employer, or whose jobs have been eliminated involuntarily, are typically eligible for COBRA from April 1st to September 30th. So 6 months of free COBRA, and that's a huge benefit to most employees.
Okay, so we're talking healthcare there, so that you've got that. So one more question before we go to break. In today's climate, there's politics on all sides. Are there conversations that we should be avoiding in the workplace? And what happens if we don't?
Yes, so what I have seen is a sharp intake in calls from employees who have engaged in conversations about their political beliefs or what they believe are politics, but may have included race or religious beliefs, even surrounding this COVID vaccine. And those conversations have been used as reasons to actually discipline them or terminate their employment. So be very careful about what you're talking about in the workplace, and especially the terminology that you're using.
So to a follow-up question, what about if it's something that you're putting on Facebook or other social media?
Yeah, you should be careful about what you're putting on Facebook. If your employer sees it, they can take adverse action depending on what it is. So if you have concerns that you've been disciplined or terminated unfairly, you can absolutely call an attorney to discuss your individual situation.
Okay, one more quick follow-up to that one. Can an employer say, hey, I don't want you on your personal Facebook page claiming that you work at a certain place, especially with what you post?
Absolutely. And that happens a lot, especially with local government, because the employer does not want to be associated with what the employee might say.
Okay, got it. All right. When we come back, we're going to tackle what benefits workers' comp actually covers and when you think you need to hire a lawyer. So we're going to tackle that and much more when we come back.